On Wednesday morning this week, the Supreme Court will be confronted with a big issue. Who are the lawyers? The former Attorney General, the famous Godfrey Adame, and the new Attorney General, who is former Deputy Attorney General Dominic Ayeni. The two lawyers have had some exchange of words and exchange of documents in terms of shredded documents here and there. But that's not the matter before the Supreme Court on Wednesday. Before the Supreme Court on Wednesday, it's a serious constitutional matter. Godfrey Adame will be alleging that Article 1466 of the Republican Constitution, which governs the impeachment of a Chief Justice, has been violated by the processes undertaken by the government of John Dramani Mahama. Dominic Ayeni will be defending the position of what John Mahama's government has done. It's all about Gertrude Torkornoo, Araba Torkornoo. Will she remain as the Chief Justice of Ghana, or will there be an impeachment process that will take her out? That's the matter that confronts the Supreme Court. But beyond that, there's something more. We're going to tell you the details of what really confronts the Supreme Court on Wednesday. So what's the Supreme Court going to look at on Wednesday? On Wednesday, an important matter confronts the Supreme Court. What is it about? A petition has come from a Ghanaian to the President of Ghana. The petitioner is asking that Gertrude Araba Torkornoo, the Lord Chief Justice, be removed from office because she's done something wrong. We all don't know what's in the petition yet, but of course, Gertrude Araba Torkornoo now knows what's in the petition. So this is the matter. Now, Article 1433 of the 1992 Constitution outlines what should happen when a Supreme Court judge or an Electoral Commission or an OSP, any other person, is to be impeached. The person who wants the impeachment, which is the petitioner, writes a letter to the president, say that this person should be impeached as a Supreme Court judge. In the circumstances of the constitutional provision, the president, in those circumstances, it's a conveyor belt. He sends the petition to the Chief Justice. The Chief Justice will make what the lawyers call a prima facie decision. That is to say, whether the person against whom the petition has been made has a case to answer. Now, the Chief Justice makes that determination, the prima facie determination, by inviting the person against whom the petition is made to make a response to the petition. So the Chief Justice receives the petition from the President, then he sends it to whoever the Supreme Court judge, whoever the petition is against, and says, this is a petition against you. They are saying that you have done X and Y. What do you have to say? The person writes to the Chief Justice, and then the Chief Justice looks at what the person has written and looks at the petition and makes a determination whether the person petitioned against has a case to answer. If the Chief Justice comes to the conclusion that the person against whom the petition is written has a case to answer, the Constitution provides what he or she should do. The Constitution provides in Article 143 Clause 3, that the Chief Justice will now form a committee. The Constitution actually goes ahead to name who should be on the committee. In that case, there are two Supreme Court judges that the Chief Justice will select, excluding herself or himself, of course, selects two Supreme Court judges and three other people who are not lawyers or are not members of the Council of State. The five of them will sit together and the petition will be heard. How is the petition heard? The person who has written the petition with his lawyer or without his lawyer will be made to confront the person against whom the petition has been written with his lawyer or without his lawyer, as he may prefer. After they have finished the deliberations, they will make a decision whether the petition should hold or the petition is dismissed. If they make a decision that the petition should hold, or if they make a decision that the petition is dismissed, whatever decision they make is final. That decision will be communicated to the president, and the president is expected to act upon the decision that the five have taken. Now, there's another twist to it. All of this, the Constitution says, or the Constitution prescribes, or the Constitution directs that all of this should be held in camera. That is to say, no media, no video, no camera, no telling of what happened, no telling another person, no complaining, and significantly, no filing of processes in courts against the process. That's very important. So that's in Article 1433. Then when you come to Article 1466, it says that where the petition is against the Chief Justice, and this is very important because in 1433 is the Chief Justice who is running the show. He gets the petition or she gets the petition, decides whether there's a prima facie, sets up the committee, hears the committee, and then communicates to the president that, Your Excellency, the committee came to the conclusion that the petition holds, so please go ahead and fire this person, sack this person, whatever the committee said the president should do, they will do it. If the committee dismisses the petition, they will tell the president that the petition is hereby dismissed. Okay. In Article 1466, the Constitution says that where the petition is against the Chief Justice himself or herself, then he, the Chief Justice, or she, cannot participate in the process the same way it is for other Supreme Court judges, because the president cannot send a petition against her to herself and say, Madam, there's a petition against you. See whether there's a prima facie. Tell her, think of your response in your head and look at the petition and say there's a prima facie. No, that's absurd. So that doesn't happen. The Constitution says that in that case, the President of Ghana and the Council of State will make the determination whether there's a prima facie case for her to answer. Now, if that determination is made for the Chief Justice to answer, the President and the Council of State will go ahead and form the committee with 2 Supreme Court judges and then 3 people who are not lawyers. They are not lawyers and they are not members of the Council of State. However, when the petition against Justice Akwa came up, it became, Justice Akwa was a Chief Justice of Ghana under John Agyekum Kufuor. Forgive me, I should have said that. Justice Kingsley Akwa, he died. May he rest in peace. Former student of Adisardel College. Now, when the petition against Justice Akwa was made, it was novel, it was new, and there was all kinds of legal arguments about it. How does this work? So somebody called Ejechum went to the Supreme Court and told the Supreme Court that in the case of the Chief Justice, he is petitioning the Supreme Court that the prima facie cannot be done by the Chief Justice because the petition is about him. So the court, led by Dr. Dateba, made a strong case that it would appear that there is a gap in Article 1466 of the 1992 Constitution. That Article 1466 regulates the impeachment of a Chief Justice. So Dateba said, leading the court, is a majority opinion. I think it's a unanimous opinion, not a majority, unanimous opinion. Dateba said, leading the court, that where the matter is about the Chief Justice, it stands to reason that the Chief Justice cannot participate the way he or she participates in the 143 process. Therefore, the President and the Council of State must run the show. That means the President and the Council of State must make the prima facie decision. Now, to make the prima facie decision, the President and the Council of State must necessarily hear from the Chief Justice in a document. They would have to, the same way the Chief Justice does in Article 143, by sending the petition to whoever the petition is against. They, the President and the Council of State, would have to send the petition to the Chief Justice that, hey, Madam or Sir, this is a petition against you. What do you have to say? When the Chief Justice gives her opinion or gives her answers or whatever it is, that document forms part of the process by which the President and the Council of State will make the decision whether the Chief Justice has a case to answer. If they come to the conclusion that the Chief Justice has a case to answer, then they will set up the panel and then they will hear it, and the Chief Justice can be whatever, whether she will remain or whether she will go. That's the process. So guess what? A petition from a Ghanaian went to President John Dramani Mahama. And rumors started, some of us heard it, some of you also heard it, I think. So that there's a petition against Justice Gertrude Tokonu, the Lord Chief Justice of today. Then later on, Felix Kwachiofosu, the government Minister for Communication, then issued a public notice that the President has forwarded the petition to the Council of State to begin the consultation. That is to say, the President and the Council of State were looking at the petition to make a determination whether or not there's a prima facie case. Because Dr. Justice Dateba in Ejechum said that in the case of the Chief Justice, the decision for prima facie be made by the President and the Council of State. People became worried. Lawyers became worried. Non-lawyers became worried. Members of the Ghana Bar Association became worried. Why were they worried? They were worried because, the petition has gone to, Ofosu Kwakye says, the petition has gone to Council of State. Did they talk to the Chief Justice before? Did they get a document from her? Did they send the petition to her so that a document from her comes out so that they can use it to form the opinion about whether there's a prima facie or not? The immediate answer they got was that no, the Chief Justice has not been consulted. Immediately, Member of Parliament for Tafo, Mr. Asifwa, who is himself a lawyer, by his lawyer, Godfrey Adame, the former Attorney General, filed a writ at the Supreme Court indicating an injunction to the process. In fact, the substantive matter is that where the petition is about the Chief Justice, the tenets of Ejechum's ruling should be obeyed. And if you're going to obey the tenets of Ejechum's ruling, you must necessarily give the Chief Justice the document so that whatever she writes will form part of the processes to determine whether there's a prima facie or not. As it turned out, the government didn't do that. They sent it to the Council of State for consultations to begin. According to Felix Kwachiofosu, Whilst this conversation was being had, a letter came out of the desk of the Chief Justice to the Chairman of the Council of State. The Lord Chief Justice wanted to find out from the Council of State Chairman why she had not been shown the petition so that she will make her input to help them to make their prima facie. The letter from the Chief Justice became a media document. Every media house got it, and everyone was concerned about why this important step, which is towards fairness, which is towards an appropriate process, and which is towards equity, was not taken. Suspicion started in political corridors. Members of the political establishment believe that there is something that has been prepared within the high corridors of the government of the NDC to necessarily remove Justice Gertrude Tokonu. They suggested that as a result of that, the government did not want to show her the petition. They wanted to railroad her into a process, take her into a committee, and as we say in modern parlance, finish her off. So Godfrey Dame and Asif West writ now stands before the Supreme Court. Justice Tokonu's letter then reached the President of Ghana. President John Dramani Mahama then wrote a cover letter to Justice Tokonu and added the petition and said, "My lady, here is your petition." But in doing so, the President was critical of the Chief Justice about why the Chief Justice's letter to him had leaked. Some people were quite annoyed with the President, saying that, why didn't you send it to her in the first place? You are complaining about she leaking a letter, but you didn't send the letter to her. You were going to railroad this against her, and now she's complaining. You are rather complaining that she leaked to the press. Who else you should leak it to? When you people saw your petition, you refused to send it to her. So that conversation is still being had. But she wrote in her letter to the President that she needed at least 7 days to respond. President Mahama was gracious enough to grant her 10 days. We are still within the period of 10 days. I think in the next 2 days, the 10 days will come. But on Wednesday morning, the Supreme Court will now hear the matter. Wednesday, 9th April, the Supreme Court will now hear the matter of an injunction. Typically, when lawyers file for these prerogative writs or they file for a writ like that, they add a prerogative relief, which is the injunction. So Asifwa and Godfrey Dame are asking for the process of the impeachment of Gertrude Tokonu to be injuncted. And then, pending the final determination of the substantive matters that they have raised in their writs, they are alleging a constitutional violation. Soon after Godfrey Dame's writ went out, lawyers started writing. Famous lawyer Thaddeus Sori wrote, discussing the Justice Dateban issue, whether the JHUM stands or not. Isankoma and others have also written. But here is our case. What confronts the Supreme Court on Wednesday morning is this. Will the Supreme Court go by constitutionalism, or will they import case law into constitutionalism? This is the issue. Now, the 1992 Constitution provides in Article 11, and perhaps I shall look at it very quickly and read it. So Article 11 is about the laws of Ghana, and it says that the laws of Ghana shall comprise A, this Constitution, B, enactments made by Parliament, 3, any orders, rules, and blah, 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 4, existing law, and E, common law. What is common law? It says here, the common law of Ghana shall comprise the rule of law generally known as common law, the rules generally known as the doctrine of equity, and the rules of customary law, including those determined by the Superior Court of Judicature. So it will suggest that the ruling of the Supreme Court in a JHUM, which insists that you must have a prima facie determination where the petition is against the Chief Justice, a prima facie determination by the President and the Council of State, that thing that a JHUM said, it will form part of a common law. And if you look at Article 11, common law comes all the way down. So, the Supreme Court will be confronted on Wednesday with a determination to look at Article 11, to look at Article 1436, and make a determination whether the case and the ruling in a JHUM is binding on the court on Wednesday morning. If the court were to make a determination that the rule in a JHUM is binding on them, then they are very likely to grant the injunction. They are very likely to grant it if they make the determination that a JHUM is binding on them. If, however, they make the determination that a JHUM is not binding on them, then they will not grant the injunction. Now, how are they going to make the determination? It's all about law, but here it is. If they go into the session on Wednesday morning and whether they want to say Ejechum is binding or Ejechum is not binding, one thing that is certain on Wednesday is that the Supreme Court cannot ignore the ruling in Ejechum. For those judges who may not want to apply the ruling in Ejechum, they will have to bring up Ejechum and, as we say, demolish it. For those who want to abide by Ejechum, they will have to bring up Ejechum and take it correct and say that the court is going to continue with the ruling in Ejechum. What is very interesting and controversial here is this. The Supreme Court is allowed to depart from its own decision. In fact, if Justice Dateba himself were still sitting on the Supreme Court and he was sitting on the matter on Wednesday, he will be able to say that I depart from my own ruling in Ejechum. So the Supreme Court can depart from Ejechum. All the 5 judges can depart from Ejechum. All the 5 judges can sit with Ejechum. So this is the matter that confronts the Supreme Court. Godfrey Adame will be arguing strenuously on the Supreme Court that Ejechum is binding on this process. And the Attorney General may be arguing that Ejechum is not binding on this process. The Attorney General may also make another argument. He may tell the courts that the matter is moot. The reason for which Godfrey Damian Asifua came to court was that the Chief Justice had not been given the document. Dominic Aini is going to say that the Chief Justice now has the document. So the matter is moot. Godfrey Damian Asifua are going to say that it's not about that. It's not about the Chief Justice having the document. It's about bad faith. It's about the fact that the government knew that they ought to give the document to the Chief Justice and they didn't. That's what confronts the Supreme Court on Wednesday morning. Let's see where the judges will go, and may the better argument win. But what we can say is that good luck to Araba. Good luck.